Hello everyone, welcome to my channel Learn Law with Professor Rashmi. After a long wait, I am again to continue with Environmental Law series. I know SEM 2 students are eagerly waiting for me to continue this series. So coming back to our Environmental Law, we are going to discuss today about principles and doctrines which are evolved by Indian judiciary with respect to environmental protection. As you all know that Indian judiciary has played a pivotal role in formulation of new principles and doctrines with respect to environmental protection. So role of Indian judiciary is basically one of the important roles with respect to environmental jurisprudence in our country. We will discuss some 6 important principles which are evolved by our judiciary with respect to environmental law, and these principles are one of the most important and relied upon principles even though we have many legislations with respect to environmental law. So these principles become inevitable part of our environmental law. These are principle of absolute liability, polluter pays principle, precautionary principle, public trust doctrine, doctrine of sustainable development, and doctrine of intergenerational equity. All these principles are not only important with respect to environmental law as a whole, but as a law student, it is important or necessary for you to know or be updated with these principles, and also they are important in exam point of view. Moving forward, today we are going to discuss principle of absolute liability. We have already discussed the principle of absolute liability in our earlier lecture of law of torts and environmental law. So law of torts with respect to environment. If we have not gone through that lecture, do go through that lecture. I will post the link in description box. Also, if you have not subscribed to the channel, do subscribe so that you don't miss any of the important videos that are coming your way. Coming back to absolute liability. We have already discussed absolute liability. So why this absolute liability principle was evolved? This was evolved or formulated for harm which is caused by hazardous and inherently dangerous industries. Scope and power of Article 32 was used by Supreme Court in this principle. And the famous case you all know is MC Mehta versus Union of India or Oleum gas leak case. So I am not going to go into facts of this case. This would be a mere revision because we have already discussed this case in detail in our law of torts lectures. Basically, the principle of strict liability which was available or which was propounded by England or English law in Rylance versus Fletcher case was diluted by its exceptions, and it was no longer suitable to Indian conditions. We have also seen the Supreme Court view saying that this principle is now not applicable or not suitable for Indian environment with respect to growth of technology and industrializations, because the exceptions are challenged and here court is not able to provide a suitable relief to general public. So therefore, Supreme Court evolved this principle of absolute liability. What is this absolute liability principle? This absolute liability principle is simply strict liability principle minus its exceptions or defenses. So any entity which is into handling or storage of this hazardous and inherently dangerous substances, it is going to liable for any harm which is caused, may or may not be its own fault. So this is what absolute liability principle simply means. This principle was re-examined and reiterated in case Indian Council for Enviro-Legal Action versus Union of India 1996. This case is also popularly known as Sludges case or H-acid case. Simple facts of this case are there are H-acid manufacturers in a village, or that industry, H-acid industry is going on, and the waste which is in form of sludge, which is highly lethal and dangerous, is just let out that way and it is not destroyed in a way it is needed to be. Even after closure of this H-acid industry, these sludges are remaining in the environment for a long period of time, and that is the reason the whole village is destroyed because of spreading of this lethal waste by causing diseases, death and disaster. So the absolute liability principle here was once again reiterated by the Supreme Court. Supreme Court said that according to this rule of absolute liability, once the activity which is carried on is hazardous and inherently dangerous, the person carrying on such activity is liable to make good the loss caused to any person by his activity, irrespective of the fact whether he took reasonable care while carrying his activity or not. So basically, Supreme Court has taken a stern stand with respect to absolute liability. Says that whatever care has been taken, and though the fault is not of that manufacturer, company or that entity, once that entity is involved in hazardous and inherently dangerous substance, it has to become liable for any damage which is caused. This is in this case this principle was once again reiterated. So one of the important cases with respect to absolute liability apart from oleum gas leak case. Now you can say that this principle of absolute liability which is laid down by Supreme Court has to some extent attained the status of statutory liability. So we do have legislation place, that is the Public Liabilities Insurance Act of 1991. This law provides that no burden on the claimant to plead and establish that any death, injury or damage is caused. So basically wrongful act or neglect or default of any person did not be proved. Once it is proved that this thing, the damage is caused because of some hazardous activity, then Public Liabilities Insurance Act would come into place and relief would be sought. One of the important and interesting case law with respect to Public Liability Insurance Act can be UP State Electricity Board versus District Magistrate Dehradun AIA 1998, where the subject matter or the main important issue for court to decide was whether electricity is a hazardous substance. So what had happened in this case? A person had died because he came into contact with high tension electric wire which was hanging at low height of 10 feet. Therefore, complaint was made to District Magistrate under this Public Liability Insurance Act, and District Magistrate had awarded the relief to the family of that dead person. UP State Electricity Board, not happy with this decision, contended this case or went into appeal, wherein it was and its contention, or basically what was the claim of UP State Electricity Board, that the electricity is not a hazardous substance and it is not coming within the definition of hazardous substance which is given as per the Environmental Protection Act of 1986, because electricity is not a chemical or not having any chemical property or not having any physico-chemical property. Basically, when you talk about hazardous substance, some chemical comes in your mind, so this was or some physiochemical substance comes in your mind. So basically this UP State Electricity Board contended that electricity is not an hazardous substance. But the court had some different thing to talk about. Court observed that electricity is hazardous. You cannot challenge that electricity is not hazardous because it can injure or even kill people if it is not properly handled. Now the point to be decided is whether electricity is a substance. What do you understand by word substance? Substance is something which can be seen. So court is saying that electricity is simple flow of free electrons. So if anybody from physics may be knowing what is electricity exactly is, it is simple flow of electrons, which is, so electron is basically a small particle of the matter and it is carrying a negative electric charge. So these electrons are material particles, so they are small parts of material particles. So we can say that electricity is a substance. Court also further observed that this particular act, Public Liability Insurance Act, is a beneficial legislation for social objective and therefore it has to be interpreted liberally. So this particular legislation is having a social objective and therefore it has to be interpreted liberally. If there are two views which are possible, one is in favor of public, then it has to be considered and literal interpretation should not be considered. This was the one of the important case with respect to hazardous substance. So see how judges need to infer or should have command on all types of fields or streams of education. It is not only law. Always You will also see that the National Environment Tribunal Act of 1995 is another significant legislation which provides the damages for strict liability, or which provides damages for accidents which are occurring out of handling of hazardous substance. So this also is one of the important legislation with respect to principle of absolute liability. So you will see that this principle of absolute liability is taken seriously by the court. So the judiciary is having a stern approach with respect to this principle. We do have some legislations coming forward with respect to this principle, and therefore this principle becomes one of the important or essential part of environmental jurisprudence. Meet you in next video lecture with another important principle, that is polluter pays, coming forward in next lecture. Till then, keep studying. Bye. Thank you.